appeal in the matter of the King on the application of Agca and the Secretary of State for the Home Department.
Yes, Mr. Collins.
My Lord, my ladies, obviously I appear for the appellant in this matter. Mr. Holborn, to my right, is here for the respondent. The court will see, well, it's agreed between the parties in their respective skeleton arguments that the correct approach to a case such as this is the open textured exercise of discretion in the round, having regard to general policy and the particular facts identified. That's in paragraph 23, the case of EK. It's referred to in our skeleton argument at paragraph 3, and in Mr. Holborn's, excuse me, at paragraph 15. So no issue between us there. Also remind the court perhaps of the Akinci case, and that's head note paragraph Roman 6, which makes clear, in fact it's clear from the guidance we say, that experience is not a prerequisite in an ECAA application. Now, although when I take the court as quickly as I can to the initial decision letter, and there was refinement as we went along, it's clear, and indeed it's clear from the judge's, the transcript of the judgment, that most of the issues fell away. And that was first of all as a result of administrative review. And usually in this case there were 2 applications, both of which were accepted for admin review.
Sorry, Mr. Collins, can you speak up a bit? You're having to compete with what I think is a bin lorry reversing or something, anyway, if you could
I'll do my best.
just turn up the volume slightly.
A sore throat as well, but I'll do my best, my lord. Thank you. So I'd referred to the admin review applications, unusually in this case. I'll take the court through those as quickly as I can. The refinement on the part of the decision maker, the respondent, but also it should be said, as a result of Mr. Holborn's pragmatic approach at the hearing before the judge, when we get to the transcript, it's clear that the issue narrowed down in real terms.
Yes.
Yeah, thank you.
I mean, in the end, there was one issue, and that was lack of business experience.
Yes, my lady, yes. That is what it comes down to, yes.
Yes, because what happened after the letter of the 1st of March, 2 points were lost. One was age, the other was potential clients. Yes. That was then revised in the document of the 30th of March. And then at the hearing, other points were, let's put it this, if not withdrawn, then were not pursued. So ultimately, it's business experience. That's it.
Yes, we're left with 1 point on it. Yes, absolutely. Yes. So that being so, I perhaps don't need to labour the route to the hearing then, because it's clear my lady's clearly grasping. Yeah. As the judge puts it at paragraph 3, it was at the heart of the matter by the time we get to the hearing. It's not a case where I anticipate much reference, and I'm really sorry the authorities bundle came in as late as it did. I, as court can see, was involved in this previously. Didn't think I was going to be involved. Came back on last week. But it's not an authority-heavy case.
No, it isn't.
No, thank you. And if we look at HC 510, it's at tab 5 of the authorities. Just one reference to that, right? It's at paragraph 21, page 189. Not the greatest copy, it's a very old document now. This came from Lincoln's Inn, as I recollect. Yes, Mr. Hall was nodding in agreement on the last occasion. But 5 lines down should read, any such application is to be considered on merits. Permission. So what the court will see that HC 510 is in very general terms. That being so, I suggest that the guidance is all the more important. And if we go to the guidance, which is at tab 6,
We haven't got tabs, but is it core bundle page 141?
the guidance begins at 190 in the authorities bundle, my lord.
Yeah.
Is it page 250 you want?
Yes, I was going to just take you to 231 first of all, the business plan. That business plans are not formal requirements, but failure to produce a business plan may undermine the credibility of the business project, business proposed, should I say. But 250 is the next page, my lady, and it is clear from that experience and qualifications, not requirements, should be taken into account as part of the overall assessment. Now, clearly, the lack of experience and qualifications was taken into account as part of the overall assessment in the initial decision, but obviously by the time of the hearing, it's the sole point the respondent relies upon. And then the next paragraph, you must examine the evidence in the context of the proposed business. The context is important in this case because, as identified in fact by UT Judge Kamara, and again, can't anticipate an issue here, we're talking about a corner shop. It literally is a corner shop in Highbury, with respect. And then the next paragraph, in some circumstances, common sense will tell you it may be possible for the applicant to establish in business, we suggest a business such as this, without relevant experience or qualifications. In other circumstances, a lack of previous experience qualifications may be a barrier. And again, the context, clearly in this case, is that of an already existing corner shop, not a shop he was going to, the appellant that he now is setting up from the get-go, so to speak, but a business which, as the judge identifies, was already profitable in the past. Those documents haven't been put in the court bundle. They were before the judge, but no issue that this was an established business which had been running profitably, and that the idea was for the appellant to take it over. So he didn't have to set it up himself. So that's the references I seek to make to page 250.
What about the fifth paragraph on the page? I'm looking at core page 141, but I think it's the same document.
Yeah.
All business persons are expected to show they have at least a basic understanding of business and financial management, including cash flow management. Was there any of that?
I suggest, my lord, that in terms, no. In the strictest terms, no. But when one looks at the business plan, which I'll take you to, and the Killich and Killich, not just the covering letter, but their first admin review application, where they in effect say, you don't need experience here. This is a corner shop, so on and so forth. That's the nearest we get to touching upon that. I accept there was no hard evidence as such. But importantly, my lord, I suggest, if we turn the page, under the subheading insufficient evidence, if the court is of the view, well, the evidence perhaps wasn't sufficient, and then I won't labour that, but it's clear in cases where the applicant does not provide sufficient evidence, you should ask them to provide further written evidence. Now, notwithstanding, and it's something the judge alludes to in his judgment, notwithstanding Killich and Killich in their covering letter saying, if there's anything we can do, let us know, we'll provide further information. And notwithstanding that part of the guidance, at no stage did the respondent ever contact either the appellant or Killich and Killich to ask for more information or evidence, to ask, what is it about this young, dynamic entrepreneur, as you describe him, that he or you say he would be able to take over and run this corner shop in Highbury. So that's an important paragraph in this case from the guidance, which was not complied with by the respondent.
Mr. Collins, was there any evidence provided either in the business plan or by the solicitors as to actual business experience?
No. But in that context, I've already referred to it. If we look at the Killich and Killich letter, it's the covering letter to the application. It's at page 254 of the core bundle. It's dated the 8th of October 2020.
Yes.
And we see there that a list of enclosures sent with, many of those don't feature in this bundle given the points I assume which have fallen away, but we see reference to the business plan, VAT records, financial statements, tax returns, and then the reference I alluded to earlier, if you require any further information before you make a decision, please contact us and we will provide that information. The business plan, which hopefully has been added at page 263 to the bundle.
I don't have it.
No, nor do I.
No, I don't.
Well, I've got, I can. I'm really sorry. I did ask for this to be added when I saw the bundle last week. My lord,
Okay, can we just look through it? I see it. It's 8 pages. Just
I'm sorry it hasn't made its way to the court.
right. It was ever thus. We have 340 odd pages of authorities, but not the business plan. We'll read it now. Yes, thank you, Mr. Collins.
Thank you. I'm sorry, see, we know this is a grocery shop, clear from page, I'll give the page, use the page numbers of the actual document. So it's company summary, page 2, organic locally grown grocery shop located in Highbury. At page 3, products, you see nothing out of the usual for a corner shop, fresh fruit, veg, dairy, gluten-free, so on and so forth. Page 5 of the business plan, under the sub-heading strategy and implementation summary, the appellant will advertise in the university daily student newspaper. And then the sales strategy subheading, an important one I suggest. The sales strategy of Seasons and Blossoms is straightforward. So my lord, my ladies, not a business which is complex, convoluted, or we say necessarily one which would demand previous experience. That was made clear in the first admin review application at page 247 of the bundle. We'll have that under administrative review grounds, Mr. Hassan Agca.
Yes.
Yeah. And points out in the third paragraph, no legal requirement the applicant should have experience or qualifications. The caseworker, 4 lines down now, has failed to understand that these are simple daily tasks in any business. General knowledge. And then the final 3 lines of this paragraph, hence the applicant wishes to purchase an existing successful business, which the applicant just needs to adapt himself and get assistance from the staff if ever needed. And then the next paragraph, I'd ask my lord to consider all of that, and my ladies. Simple commercial transaction, which will be run by a young individual, does not require the individual to possess any sort of qualification. We go back to the guidance and the common sense approach. And that's the point Killich and Killich are making there, as is the following one. There is no course available to teach you how to run a grocery shop. Unreasonable for the Home Office to make such what's referred to as an allegation. And that point, it's at 183, Judge Kamara's order. She, the judge, that is, makes the same point when she granted permission. And I suggest it's a well-founded point. You'll see, my lord, in view of, I'm at 183 now, the order. The respondent accepting the applicant as a hard-working individual with unique ideas. In that case, arguability, of course, but reference to a modest grocery shop. That we suggest is the correct approach, the common sense approach, which should have been adopted by the decision maker. And that submission, I suggest, my lord, has all the more force, given all the other points fall away. In the initial decision, of course, this was one of 6 or 7 points. One by one, as a result of admin review applications and Mr. Holborn's very pragmatic approach by the time of the hearing, they fall away. So this is all now revolving around lack of experience and qualifications, which the learning and the guidance make clear is not a prerequisite. And finally, my lord, can I just touch upon the judge's judgment itself?
Yes.
Yeah. Begins at paragraph 30 of the core bundle. And court will see paragraph 5. Business was on the face of the business plan profitable at day one, and I've been shown accounts for the last period before acquisition. So they've not been included in this bundle. I hope that's because there was no issue as to those, but it would have been helpful perhaps to see that this was not just an up and running business, it was a profitable business. But they're the observations the judge makes. So no concerns about the business or the credibility of the business per se, or the credibility of the appellant as he now is. Paragraph 9 of the transcript, the way we put the case at the hearing, at heart this business was a shop. Mr. Agca, a young, hard-working man, that was accepted by the respondent, the decision maker, and there was capital in the form of a gift available for this endeavour. Emphasised that experience not a prerequisite. Indeed, there was no issue as to that. At paragraph 11, the judge makes clear that the other points which remained on the run-up to the hearing, other than experience and qualifications, were not just very poor points, my description, that those points cause a worry about what it was that the decision maker was giving weight to. But ultimately, the points are not relied upon. So we're left with 1 point and 1 point only. At paragraph 12, the judge states that it's not the case that the Secretary of State can necessarily be expected to ask if there's a point here, a point there. But Mr. Agca's solicitors have said right from the beginning they'd be pleased to provide any further information. But also, my lord, I've taken the court to the guidance, which states in turn that that is what should have occurred, and it didn't in this case.
Well,
and then
there
finally,
may be Mr. Collins, there may be an argument there that what the guidance contemplates is that some evidence has been provided, but of itself it's insufficient, and for example, other documentation substantiating qualifications could be provided. Not in a case like this, when absolutely no evidence at all is provided.
I accept, my lady, it could be read that way, but again, looking these applications as they then were, no longer is there any ECA application, but they're very fact specific, obviously, and the context is the thing. If this were a much more complicated business, then of course what one might, as a decision maker, be expected to say, well, what courses have you done? What qualifications have you got? That's why, my lady, I took the court to Kilic and Kilic's first admin review application, which I suggest is cogent, which is what do you need to run a corner shop, an already existing corner shop?
Well, it might be, I suppose, that you might have worked in a corner shop before. You might have that sort of experience. It's not necessarily a question of qualifications from a college. It's about knowing what to do, and what's suggested here is an 18-year-old with no experience at all should start running a business. And it's easy to say, well, how hard can it be? And the answer is probably quite hard if you're responsible for all of it.
My lady, but I would suggest that I accept obviously what my lady says, but as a point, a freestanding point on the part of the respondent, the decision maker, it doesn't have the force, if one likes, given all the other points have fallen away. We look in the round. This is all that's left now. So everything else is accepted. The gift is now accepted, £60,000. The family background, the uncle who provides the gift. The age point falls away. That fell away in the first admin review application. So we are left with this one single point. And I suggest it's wrong, without more, for this application to fall away as a result, particularly when the respondent did not, the primary decision maker, did not contact the appellant or Killich and Killich to say, to raise the point perhaps my lady raises, which is, you say you're a young, vibrant, hard-working man, we acknowledge, we accept, but how does that mean you can run a grocery shop? They don't ask that question.
But what, supposing they had, what would the answer have been? As our lady said, there's a distinction between qualifications in the formal sense, diploma from a college or whatever, and experience. I'm prepared to accept for the purpose of argument that you probably don't need to go to a college and get a diploma to be able to run a grocery store of this kind, I think. But if it's right that your client had never worked in such a store, or at any rate there's no evidence that he had, possibly that he never worked anywhere, that this might be his first job. We don't know, and the Home Office decision maker didn't know either. Aren't they entitled to say, well, the lack of experience is a very serious problem? I think if he had relevant experience, for example, I worked in my cousin's grocery store somewhere or other for 18 months. I took care to talk to the bookkeeper. I took care to talk to the stock controller. I've learned the following thing. I think we'd know about this by now, wouldn't we?
Well, but certainly, I accept that, my lord. What one would have hoped, it would have formed part of, if not the application, representation. I think that the nearest, as I say, I took the court to admin review application 1.
Yes.
Yeah, and that's the nearest we get to that, which is saying, look, you don't need it. So presumably, yeah, I accept that there's nothing within even the admin review application which states in terms that he has ran a shop before or worked in a shop before. The appellant's case is that this is such a simple, straightforward exercise. He does not need to have had that experience, as I read the application for admin review. But again, I go back to we go back to the guidance, which particularly, I don't wish to keep repeating myself. This is the sole issue now. Surely it was incumbent on the decision maker to approach, and that's how I read the guidance, to approach Killich and say, look, make the points my lord has made. And if they weren't answered adequately, then we wouldn't have a case to say, well, your approach is irrational or unreasonable. But at no point, as I read the respondent's position, it's just repetitive, and indeed could be said the appellant's cases, in the sense of the way it was, the representations put forward. But at no stage did the respondent put it to the appellant or his solicitors in the way my lord puts it to me, which is obviously a fair point. If it had been put and not answered adequately, then we may not have cause for complaint.
Would he have been entitled to work in a corner shop under the terms of his visa?
Whilst
before he applied, before he wanted to change his status?
Oh no, it would have had to have been. It would have had to have been in cases such as this. It tends to be so. If someone's a roofer or whatever, I did that back home in Turkey. It's no, he wouldn't have been.
Couldn't have been any experience in this.
He was here as a visitor, so it was a switching application. Yeah, what one, the evidence one would expect, my lady, would be, oh, back home, I worked in so-and-so shop, my family shop for X, Y, Z years or whatever. But no, he wouldn't have been able to work in the United Kingdom. And then the final references to the transcript, paragraph 14 and 15, I would take the court to. And it's the point that the court is saying there is no sign of experience of managing staff which were to be part of the business. Although experience is not a prerequisite, an account is taken that it was absent here and not accompanied by anything like sufficient explanation. The ultimate decision is one the respondent was entitled to reach. We say, with respect, that is the wrong approach, but that is what is at the heart of this appeal, whether on this one remaining point, the respondent was entitled to reach that decision, and whether the judge was correct to uphold that. Unless there's anything else, that's all I've got to say at this stage.
Yes, thank you very much, Mr. Collins. That was very succinct. Mr. Hayburn.
Thank you, Lord and ladies. You've heard much from Mr. Collins as to why the application should have been granted by the Secretary of State. But I would just highlight, of course, this is an appeal. And the grounds of appeal are, in fact, that experience has been elevated to a criterion. This is at page 26 of the bundle. And it's put in two ways. But it's essentially the same point. The first is that the respondent's decision and the judge's endorsement of it elevates experience into a prerequisite which is irrational. And the second is that by focusing on business experience, there hasn't been the open textured consideration. What it's not is a challenge to the Secretary of State failing to go back to the appellant to ask for further information. I accept that may be relevant by way of background, but it's not in fact the ground of appeal, just to be crystal clear, nor is it indeed a straightforward overall rationality challenge, although again I can see that it's very adjacent to such a challenge. The point I make here is that this is not a decision where the issue of business experience has become anything other than the decisive point, but not a criterion, which is two entirely separate ways of putting it.
Well, let's not use criteria. Of course, it's a criterion. Prerequisite is
Prerequisite, sorry.
critical
Prerequisite.
word, isn't it?
Prerequisite,
Yes.
sorry. Yes, that's a better way of putting it. Yes. Prerequisite. So, the second point I'd like to make is the nature of the decision and how we got to it and the concessions made in the first instance hearing. It was accepted that issues as to, there was a minor issue as to £156 of bank charges and as to corporate entities could have been resolved by questions and didn't really add much. However, it was still relevant that this appellant, his proposal was to spend his entire £60,000, and indeed plus £156, which he didn't have initially, on buying the business. There There are no funds left, and that is, in my submission, relevant when we come to the issue of business experience and particularly financial experience. So, looking just briefly back to the immigration rules as applied, HC 510. I just wanted to flag up a couple of lines in that which are of particular importance and underpin the decision, and I hope help give one a feel for the process the decision maker is going through.
Yes.
I've quoted my skeleton arguments because it's easier to read. I'm going to use that, if I may. It's verbatim from the copy that you've already been taken to. So you will see 5 lines down, this is paragraph 13 of my skeleton. 5 lines down, starting permission. Permission will depend on a number of factors, including evidence that the applicant will be devoting assets of his own to the business. A number of factors. A little further down, the applicant's part in the business must not amount to disguised employment, and it must be clear that he will not have to supplement his business activities by employment for which a work permit is required. In essence, it's got to be the kind of business that's going to be successful. He's going to be able to have to make money out of it. It then refers to joining an existing business and evidence to establish its financial position, terms in which he's going to enter into it, and that there is a genuine need for his services and investment. Again, inferring a level of experience that means he can run the proposed business. We then get to the guidance, and I've quoted again. You've been taken to it already, but paragraph 14, and the guidance makes crystal clear that experience and qualifications are not requirements, but should be taken into account. So the guidance, there's no complaint that the guidance isn't lawful, and accurately describes the question that must be asked. And then further down at the bottom, it's already been referred to, all business persons are expected to show that they have at least basic understanding of business and financial management, including cash flow management. So that's quite important when we then get to the nature of the decisions. I'll briefly refer you to the relevant parts. Page 235 is the first decision, and these are, well, it's the second decision, in fact, of 3. It's the second and third decisions that matter. They're to be taken together. It's exceptional that certain points in the first decision are abandoned. But if you go to page 236, you will see that the core reasoning here is to business experience. It refers to, it's a slightly poorly worded first sentence, whilst you claim there is no legal requirement. It explains in that second sentence, top of 236, experience and qualifications are taken into account as part of the overall assessment of the evidence provided. So that's what's going on here. The relevant test is being considered. The relevant question that's part of the open textured consideration is being considered. It then explains some of the concerns in broad outline. It's not unreasonable to point out that you have no prior experience or qualification to run a grocery store business. And being a hard-working individual is, in the view of the Secretary of State, not sufficient to run a business. In my submission, those are entirely rational points to make. It then deals further with the hiring of staff and the apparent need for assistance, highlighting the lack of experience and why it's reasonable to expect that a person wishing to establish in a business should know the industry they are proposing to establish the business in. You have no prior experience of running a business. You appear to be reliant on existing staff to support you. So, that's the first decision. My submission plainly considering all the relevant aspects of this issue. Page 221 is the final decision which is relevant. Page 223 has the relevant section. The bottom. And explains, again, refers to the policy guidance, needing a basic understanding of business and financial management, including cash flow management. It highlights there's not been any experience and no evidence of experience or leadership skills. Now, as I say, it's not in fact strictly a ground of appeal, but I highlight here that you will have seen both the decisions there have highlighted the lack of experience. It's difficult to see how the appellant could have been more clearly invited if he had further evidence that he said should have been asked for. Could have been invited more clearly to have provided it without saying, please provide this evidence, which in my submission is not something the Secretary of State is required to do. The gap has been explained to him very clearly. We then get to the judgment, and I will briefly touch upon that. We can take you through the relevant paragraphs, and I won't repeat them in full. To page 27. 32 has the relevant points, and the judge, paragraph 13, is clear that he is talking about the decisive point, not the only point, but the decisive point is that looking at the matter through a common sense lens and in the round, the Secretary of State was entitled to hold and apply a concern in the context of this case about the absence of experience. And then it explains why. This isn't just saying that the claimant couldn't possibly have met the test. It says that the business plan did not address that with any sufficiency and did not acknowledge it as something that would require some further explanation. Here it was for Mr. Agca to explain. We then get reference to a submission I made in that hearing as to working capital, which, to be crystal clear, is by way of an example as to why someone looking at the business plan as a whole might be concerned, if you look at it in a bit more detail, as to the issues facing the appellant. He's spending his entire £60,000 on buying the business, and he's got his figures for costs, etc., and alleged profit for each year, but has not explained or given any indication that he understands issues of cash flow, which you need working capital, buy stock before you sell stock, and the like. How is he going to deal with that? The judge himself could see the issue which the Secretary of State's decision very specifically referred to, which was in relation to managing staff. These are but examples of what the Secretary of State's decision is concerned about. Cash flow, which, as you saw, was specifically referred to and is something drawn from the guidance, and managing staff. Nothing has been identified, nor is a ground of appeal pursued that says, oh, well, the Secretary of State failed to take into account some very clear, relevant consideration or piece of evidence. In my submission, there is no basis for saying that business experience has become a prerequisite. It is rather that being able to run a business is prerequisite, is essential for complying with HC 510. As we saw at the start, that is what all of the points in there infer. You must be able to run a business, otherwise you can't fall within that provision, which is about allowing business people to set up in the UK legitimate businesses. I think unless I can push you further, those are my submissions.
Thank you very much. Mr. Collins, obviously no need to repeat anything,
No.
but is there anything to which you'd like to respond?
Just that the reading, I'd suggest the reading you were taken to paragraph 21 of HC 510 infers, as Thirlwall says, infers a level of experience. I suggest that's certainly not reflected in the guidance, and I would suggest not actually reflected in, although I accept HC 510 is in very general terms. That's the first point. And you were then taken to the admin review decision 236. We say, we've made the point actually that review does overlook the simplicity of the business proposed here. The third point is that this was the decisive point. In fact, it's clear, as I read the judgment, paragraph 11, page 32, the other points are not relied on. This is all about business experience and stroke qualifications. That's the sole point. And finally, my lord, the business plan you see from the authorities which we follow, it often is the case that the business plan itself is criticised by the respondent in cases such as this. Here, the business plan isn't criticised. We've got an already running profitable business. The judge alludes to that. It's not said that this business won't continue to be profitable. It is said that you won't be able to successfully run it for those two reasons only, which is lack of experience, it's not so much qualifications, I think, it's experience here. And we say it is, in the context of this corner shop, too simplistic and too irrational an approach. And I thought it was fairly clear from the grounds, the way we challenge with respect the judge's approach in sustaining the respondent's decision as elaborated upon in the admin review decision, which is that this was all about the knockout blow, so to speak, the knockout point was you've got no experience, therefore all of this should fail. So that's all I've got to say in response, Madam. Thank you.
Well, thank you both very much. I would like to have these proceedings filmed and shown to students as an examples of concise advocacy. The number of hearings I've sat on where we've been up against a time limit because people are making 57 different points, 55 of which are irrelevant. So we're very grateful that you've concentrated both on the narrow issue. We will take time, hopefully not too much time, to consider our judgment and send it out in the usual way, in draft, as I'm sure you both know. First of all, under the usual embargo as to publicity, and see the Counsel General for Wales case, and secondly, not for re-argument, but simply for correction of typos and factual errors and so forth. Thank you both very much.
All rise.